avoid probate, and maybe some might actually send things directly through probate versus, if you don't have a beneficiary designation at all, what might happen on an account or a home or whatever it might be. And then you'll also receive from us our feedback form, which gives you a place to put down any constructive criticism you have. We're always open to that. But also if you'd like to reach out or have us reach out to you rather to set up an initial consultation with our office. And those are complimentary. They don't cost you anything to come in and talk to us. We do schedule them for about 2 hours and ask for quite a bit of information when you come in. But if anything we talk about today is important for you to talk about with one of us, that can be a really good use of your time. And then just a reminder that next week is our public seminar, our Wills versus Trust public seminar at the Neville Public Museum up in Green Bay. There will be a 2 and a 6 p.m. session. So if you want to sign up for that, please do so at estateplanninglive.com. Seating can be limited in those things. So if you're interested in attending, go ahead and do that. So to get started, and one last thing, because I apparently can't remember to, with this is interactive. So through the Q&A function, you can send in questions and we'll see them come up and answer them either at the end or as we see them come up, depending on how many questions we're getting. Yeah, with that, so when we're talking about like what a personal representative is, I mentioned earlier, sort of alluded to earlier, that is the same thing as an executor. The more common terminology these days in a lot of states I've noticed is personal representative. It's just kind of more consistent than it used to be. But a personal representative is the person nominated in the will, much like that executor was, to handle the probate estate. So you, when you're nominated in that will, though, does that mean you can immediately start acting as the personal representative?
No, and a lot of people are sometimes confused about that. They'll think, well, I was listed in the will, I'm nominated as the personal representative, so I'm just going to take that will down to the bank. I'm going to start paying bills and taking care of things. It's still just a nomination, though. So when you're going through the probate process, part of that means that you have to be approved by the court.
Mm-hmm.
So you would be issued then a letter that would actually approve you as a personal representative before you could ever start paying bills and kind of, stepping into the decedent's shoes in that way. And with nominations, sometimes what people don't realize too is what would happen is the heirs to that will would receive notice, that you are going to be the personal representative. So you have to, let them know about that. But the same thing applies to anyone who would be considered an heir at law. So for example, if a child or someone who would otherwise have received from the estate was disinherited, they are notified too that this probate is starting and who the personal representative would be. So that can typically take about 30 days, but then once you're personal representative, you can get access to bank accounts and, start to really, you step into the decedent's shoes and you're in charge of, helping to see the estate through the probate process, which, typically we see probates last as long as a year, maybe more, year and a half.
Yeah. So one thing that's important to remember with that role as a personal representative is some people who are in that role might have also been the financial power of attorney agent for that person too. A lot of times they're the same order. So at death, that financial power of attorney authority ends. So you can't access the bank accounts anymore through that authority. As Abigail mentioned, you have to be acting as that personal representative, but it's not as simple as just taking the will down to the bank. And that approval from the court is necessary before those accounts can be unfrozen and you can start to pay bills and do all of those things. One thing that can lengthen out that approval process, as Abigail sort of alluded to, was that if somebody contests your appointment as personal representative, especially when there's somebody who has been disinherited under the will and is given that notice, that month period can be longer. I mean, anytime in this sort of process, if there's objections to things, if somebody is objecting to the will or objecting to your nomination as personal representative, it can stretch that process out further than it would be if it was everybody signed off relatively quickly. But in most cases, yeah, it's usually about a month. And that month is not because it takes that long for people to sign things, although sometimes it does. But sometimes that's just the deadline the court set. And if people don't sign off, but then they don't appear at any sort of hearing later on that's set to object, then their objections are waived. So I would say consistently, that's been my most common experience when somebody doesn't sign off on somebody's appointment. So if some beneficiary just forgets to sign off on your approval as that personal representative, I'll appear by phone in front of the court and they'll say, the person never showed up, the objections are waived, the approval can go forward. So it's not that people are commonly objecting, it's that people forget more than anything.
Sure,
else.
or they may not feel comfortable,
Mhm.
signing off, because a lot of times, it's very, big general language of, you're waiving all your rights, and they may not feel comfortable or fully know what that means. Especially if they weren't in a good position of having contact with the decedent,
Mhm.
they might want to just, kind of quietly abstain from the process as a whole. So.
Yeah, and then once that approval has occurred, Abigail mentioned domiciliary letters. I sort of think about those in a way of like, this is the power of attorney for the estate. It's not a 1-for-1 comparison, but that's a kind of easy way to conceptualize it, of saying, okay, this is what I take as proof that I can act in this role. When you're talking about what your role is as personal representative, it's to act, fill in the shoes of the decedent, as Abigail mentioned, but your role is also to maximize the value of the estate for the beneficiaries. So some of the duties that might entail is, not necessarily being a financial whiz or watching the markets or things like that. I mean, that's not expected of you, but you do have to give notice to creditors. And those are direct notices given to known creditors. So like if I knew that I had a mortgage on my home, my personal representative would have to give notice directly to the bank that, yes, I've passed away. But we also have to give public notice to, any potential creditors. And that's through publishings, usually a newspaper or online newspaper, some sort of article that these creditors can see that, well, we have a certain period of time to come forward, which is give or take 90 days, depending on the exact deadline the court sets. And they have that period of time to come forward, file a claim against the estate. But what happens if they don't meet that deadline?
Well, what would happen is then they would have, no claim against the estate if they miss the deadline. And that can be helpful. I mean, we've seen it in cases too. And, I'm just going to pick on hospitals a little bit. They will say, well, we lost this paperwork on our desk, or, this bill got shuffled around and now it's, 6 months after that deadline was, well, then they're just out of luck and the estate ends up saving that money. They don't have to pay that bill. Creditors have to meet that deadline. So, and that helps with the liability too, because you don't want your personal representative or, the people, your beneficiaries or your heirs liable for your debts and your expenses. It is your personal representative's duty to make sure that, bills are paid. They're also going to want to really track their receipts and expenses, keep track of the bills that they pay. And then let the beneficiaries know what's going on, what costs are going out. So they really just step into your shoes and would manage bills and making sure everything is filed on time. The biggest thing is those court deadlines, making sure that they're aware of them, they're following what they need to at different times. So it's very organized in that way.
Yeah, and I mean, the hospital's bill is a good example. I mean, there's usually some sort of hospital bill out there after someone passes away. I did have that exact situation where it was months after that 90-day period of time had ended, and the hospital tried to come forward and say, well, we're sorry, it got lost in the paperwork somewhere, so we're going to try to file that claim now. And we advised the personal representative to tell them, no, sorry, you had your deadline and you missed it, and that's not our problem, and it's not the personal representative's problem. So as Abigail mentioned, that can really save money for the estate. And when your duty is to maximize that value, if a creditor doesn't have a right to pay it or to get paid anymore because of their own inaction, that does help maximize the value of the estate. It's also why it's so important, though, to give these notices out so that you can preclude those future claims. What often happens is when people, are not necessarily even the personal representative, but have not given that notice to the creditors properly, they can have some of that potential liability for, well, you didn't do your job, right? You didn't meet your obligation and give these notices out. They can become personally liable for it, whether it's them transferring things outside of probate or it's as a personal representative. And one big example of where that can be a problem is really with if the person who's passed has received any amount of Medicaid and there's a state recovery from the state where they can come in and act as a creditor. And if they're not given proper notice, they can come after the estate again and say, hey, look, we were not paid this money and this money was owed to us and it was transferred outside of, probate maybe, or it was transferred without giving us any information on it. So once that notice is given and that time period's ended, that's where you can start to make distributions out to beneficiaries. It's very important that beneficiaries are, entitled to information or to know that they're entitled to information so they can request accountings to see how that estate is being administered, what expenses are coming and going, that kind of thing. But it's also, once those expenses go out, or not expenses, rather those distributions go out, there's still things that you have to do to close out that estate. So one of the things that's really big when it comes to closing out the estate is making sure the final tax return is filed for the decedent and for their estate for that year. Turns out even if you pass away at the beginning of the calendar year, you do still have to file your final tax return. It depends on income, of course, but you still, for the estate, have to file that return nonetheless. So one thing that can be really important for a personal representative to know, though, is how much information people are entitled to. It can be important to protect minor beneficiaries potentially. It can be important to protect disabled beneficiaries, or how much information that the disinherited child is entitled to. With probate, it's potentially more public than it would be avoiding probate. And so that is where some people are going to have access to this information to, potentially request a copy of the will, see who's in that. It doesn't always happen, but there's a little bit less you can do as a personal representative to restrict some of that access to information with adult beneficiaries than you could through a trust, for example, as a trustee. So there are certain things that people can find out anyway, but when it comes to after that person's claim is precluded, they have no right to information on those future beneficiaries or how their shares are being funded anymore. So that's just important to know to protect those beneficiaries as well, especially if they're disabled or minor beneficiaries. So one thing that you want to do when you're potentially liable to those beneficiaries, if you're not keeping proper records, is keep track of those expenses, keep track of how those distributions are being made, how those shares are being funded, right? The shares of the estate, because beneficiaries can request that information and they're entitled to it. And so one of your duties as that personal representative is just to make sure that you have met your obligations from a fiduciary standpoint, that you've paid the bills properly and that the expenses were reasonable and that you didn't take like an unnecessarily high personal representative's fee, which a court would have to approve.
I was going to
anyway.
mention too is you would be entitled to a fee for your role as personal representative. The other reason too, and just as a general kind of probate concern, is there are also court fees associated with probate. So it would be personal representative's fee. If you would hire an attorney's office, they would take a fee from the estate too, as well as court fees. So those are kind of the big three to be aware of. As far as, fees kind of at the end, minus the expenses and debts that you'd already kind of dealt with.
Yeah, and how much of a fee that personal representative is entitled to take, it's generally under what would be called a fair and reasonable standard. As you can tell, that's pretty vague. It's not a statutory, this is the amount you can get paid, it's fair and reasonable. And so it's generally what would a professional get paid, but probably a little less because they're not a professional. And how much work is that person actually doing? Personal representatives, if you have to, while accounts are being unfrozen, while you're waiting for your domiciliary letters to show that you are that personal representative, if you incurred personal expense on behalf of the estate, you can of course get reimbursed for that, assuming that there's enough to reimburse you. I mean, creditors might get paid first still. But on top of that, you can also take that personal representative's fee. That's whether you're a beneficiary or not. Now, if you are both a beneficiary and a personal representative, there's some tax implications for you taking that fee. It is compensation, so that means it is taxable income to you. Whereas as a beneficiary, if somebody just handed me $20,000 in cash as a beneficiary, I don't necessarily have to pay tax on that. So there's some tax considerations there, but especially if you are not a beneficiary of the estate and are a personal representative still, I always encourage those people to take what they're entitled to as a fee, because it's, they're still doing work. It's not like it's, on autopilot. Even if they've hired an attorney, there's still things they have to do. So it's completely acceptable to take that fee. When it comes to, speaking of attorney's fees, what can somebody expect, generally speaking, in terms of attorney's fees?
Yeah, typically we say 3 to 5% is about what we see for attorney's fees when you're in the probate process. The next question people might have is, what's the difference between fees, attorney's fees related to a trust, which we typically see as a % or less for attorney fees for trust administration, but fees for probate administration would typically be that 3 to 5%.
Yeah, so I mean, that obviously ranges a lot. That 3 to 5% is a pretty big range. It depends on the attorney's office who is hired, how they charge, whether it's hourly or on a flat fee basis, or if it's, I guess what their hourly fees are, and whether or not a professional fiduciary is chosen as a personal representative. That would obviously increase that fee a little bit too, whether it's you as an individual or if you opted instead for your own planning to have a professional company do it. So one thing when you're getting started, kind of trying to figure out from, after you're approved as that personal representative, what actually is a part of the estate, it's important to look at what did that person have? What types of assets did they have? And so gathering information is really important. Not just the bank accounts, not just the real estate, but did they have a financial planner they worked with? And did they have retirement accounts? How are those designated? Because depending on how some of those assets were titled or designated, some things might be a part of that probate process, and then as personal representative kind of be under your purview. Other things might be completely outside of that process. And it's important to know kind of on the starting point of which assets are under your direction at that point. So a very common thing that you would see avoid probate would be like a retirement account, an IRA or a 401k. A lot of times those are directly left to beneficiaries. So
for good reason.
And for good reason. For good reason. Yeah.
So with the Secure Act, which was a change in 2020, if the beneficiary of a retirement account used to have their life expectancy to stretch out that retirement account. So, they would take small amounts each year. But now after the Secure Act, every beneficiary with, very few exceptions, has 10 years. So they have 10 years to kind of take out money from the retirement account, which most of the time, unless you're talking about a Roth IRA, does mean that they're paying their income tax, with those distributions. However, if a retirement account was to go through probate, that 10 years is even shortened to 5 years. So that's why you really, want to perhaps have that retirement account avoid probate. Now, if you're at a point of just kind of handling what's in front of you, it's just something to be aware of, that you would have that shortened timeline if that retirement account was passing through probate.
And whether or not there's a 5-year or a 10-year payout when there's probate involved also completely depends on whether the person has started taking their required minimum distributions too. So it can be complex, but it's really important for you to figure out if that asset is going through probate, like something like a retirement account, what are the tax implications for the estate? What are the payout implications for the beneficiaries? But one thing, if you're setting up your own estate, that you can do to make your own personal representatives' lives a lot easier is make sure that if you have a will and you're intending to use probate as part of that process, which is if you have a will and no trust, that's what you're basically telling people you want. Wills only direct probate assets. So if you want to make your personal representatives' lives a lot easier, is make sure you have things designated properly to go through probate. I think a big mistake a lot of people make is when they want their will followed, they maybe mirror that in beneficiary designations with payable on death or transfer on death. Or if they want someone to pay expenses as that personal representative, they'll leave a certain account directly to that person to pay those expenses. Well, the problem with that is then it's not going according to the will, because those designations avoid probate and therefore are not subject to the planning you have in the will anymore. If you leave that account directly to the personal representative, there's a couple big problems with that. One, they're just now the beneficiary of it and don't have to split it according to the will. I think we all would hope that that would happen. But the other problem with that is what's going on in your personal representative's life. Do they have debts of their own? Do they have liabilities of their own? And if you just leave money to them as a beneficiary, that money may not be available to pay off the expenses of your estate anymore, because now they have to use it for their own liabilities. So like things like cash accounts, life insurance, those are pretty big ones that I would say in general, it makes perfect sense to say, these are going to my estate, not directly to my beneficiaries, so that the personal representative has access to these funds to pay expenses out of those funds before they get divided up to all the beneficiaries, and so that their own personal life liabilities are not applying to those assets. But that doesn't mean everything will go through probate. So you as the personal representative just need to know, what is the estate? What do I have to handle versus what's completely outside of that at this point? What's not my responsibility? And so gathering that information is really important to make sure that you are starting off on a good foot, that you know what is part of the estate. It makes your life a lot easier to have that information. It makes the attorney's life a lot easier, and it can expedite the process. One example of that not happening, where there can be a lot of problems, is I had a client who a husband passed away, and he handled all of the finances. He passed away the day before they were supposed to come in and meet with me to get their planning set up. So it was not planning that we had set up at all. And the wife did not know about any of the accounts, didn't know what was going on in general in their financial situation, because she never had handled it before. But it also made the probate process, that year to a year and a half, take about 2 years instead, because we were waiting to gather information for her to get things in the mail. So if you're trying to make your personal representative's life a lot easier going forward, make sure you have a list of these accounts, or at least talk to them about who manages these accounts so that they have access to things. If you know you're named as a personal representative in somebody's will, talk to them and ask them if they would be willing to share some of that information with you, just so that they know where to look when things start. Because I think that's probably the biggest roadblock initially that people run into, is they have no idea where to even look for these things, understandably. So yeah, knowing where the assets are is really important. And knowing that you're not alone in this, I think, is really important too. I think too often people try to go it alone and think that, oh, I can handle all this, or, I shouldn't, burden the estate with a higher expense of hiring a CPA or hiring an attorney to help. But sometimes hiring those people, those individuals, can really help save the estate money. On the attorney side of things, can expedite the process, make sure nothing gets missed. From a CPA side of things, making sure that the proper tax elections are being dealt with for the beneficiaries, that the estate is, accounting for everything. This can all be very helpful. So yeah, it involves spending more money, but it's not, it's often saving money in the long run for the estate. There's a lot of examples out there of a personal representative trying to deal with this by themselves, and the estate taking much, much longer than usual. So, I don't know if you had anything you wanted to add on that.
No, I think it's just also an ease thing. Probate is going to have a lot of deadlines, maybe terms that you aren't used to, and having someone just to guide you and give that peace of mind that you're doing the right thing has value too.
Yeah, and knowing that nothing gets done immediately when it's in probate, or I should say things don't happen immediately. A lot of probate is kind of hurry up and wait. The court has their deadlines. You need to file things by certain periods of time, and then they'll give you the next deadline. And it can often feel frustrating of, I just want to get this done. And of course, nobody wants it to take a long period of time. But these deadlines are there for a reason, and they make sure that everyone's given proper timeframes to come forward, whether that's to contest things, or as a beneficiary, or to make sure that the accountings are done, or creditors are given notice. So that year to a year and a half is a long time, but don't expect it to get done in 2 months or 3 months. I suppose some estates might be if they're very efficiently handled, and also totally depends on the way the assets were designated as well. So with that, I guess I'm not seeing any questions, but if anybody, has any questions regarding acting as a personal representative, you can always email learnmore@hooperlawoffice.com, and that will be forwarded to one of us as well. And just a reminder that keep an eye out for those feedback forms where you can let one of us know that you'd like to reach out and set aside time and meet for that initial consultation. And again, those are complimentary. They don't cost you anything to come in and talk to us. So if you are a personal representative, or you're trying to get your planning in place so that your personal representative's life is a lot easier, that's a good use of time for you. And then usually by the end of that meeting, we can give you an estimate of cost to do planning or to act as the attorney for the estate. Just another quick reminder of if you are interested in attending that public seminar next week at the Neville Public Museum at either the 2 or the 6 p.m. slot, go ahead and sign up for that at estateplanninglive.com. And we hope to see you next week. Oh, sorry, I do see one question. Just one quick question was, where's the form for the initial consult? You'll get that in your email. So the email you use to sign up for, the invite for this presentation, it'll be sent to that same email after this is done, along with our little what goes through probate and what avoids probate chart. So keep an eye out for that. And if for some reason you don't get it, you can always reach out to us directly to, through the firm, and that would be totally fine too. We can send you all the same paperwork. So, any other questions before we let you guys go enjoy the nice warm weather?
Yeah, it's supposed to snow on Friday, and I've
Oh,
heard
never
people
mind.
say I've heard people say it's gonna be a lot of snow too, which just feels like we're never gonna. We talk about spring a lot here, like really wanting springtime, but yeah, we might be due for some more snow. So
yeah. So anyway, thanks for joining us, guys, and enjoy the warm weather while it lasts. Anyway, and we'll hopefully see you